Good evening, I'm Ryan Doyle, sitting in for Michael Corrin tonight. It's an idea that has criminal defense lawyers and civil rights advocates squirming. The federal government is considering a move to collect DNA samples from suspects upon arrest for certain crimes, which would mark a significant expansion of the current DNA databank laws. The idea of someone being arrested for a heinous crime and then swabbed for their DNA before being found guilty probably doesn't sit well with you. But this idea does have merit. Decades ago, taking a mugshot and obtaining fingerprints upon arrest was considered new technology. Yet in 2013, we still rely on antiquated methods to catch the bad guys, even though new technology is available to make it easier to put criminals behind bars. Currently, Canadian law allows for DNA samples to be taken from individuals who are convicted of a range of offenses, including murder, sexual assault, and in some cases, dangerous driving and drug trafficking. The information can be used to link a suspect to a crime scene or eliminate them where a profile in the databank does not match the DNA collected at that crime scene. Calgary's chief of police, Rick Hansen, thinks the system is in need of a 21st century makeover. He told reporters yesterday that it just makes too much sense that the federal legislation be amended to include DNA samples upon arrest, so that, number one, you ensure that you've got the right person, that he is who he says he is. And number two, it would clear huge numbers of crimes where we have evidence, but we haven't yet linked that evidence to the perpetrator. Imagine all the police resources that could be saved by knowing the right person is in custody. Not to mention the fact that innocent people who are wrongly accused would automatically go free, no longer mistakenly locked up for a crime they didn't commit. Even in the land of freedom and liberty, the United States of America, this idea has already cleared the highest court in the land. Earlier this summer, the U.S. Supreme Court gave the green light to allow 28 states and the federal government to take DNA swabs after arrests. One of the cases they reviewed speaks volumes as to why Canada needs to allow the same process here. A 53-year-old Maryland woman was raped and robbed, but no one was arrested. Almost 6 years later, Alonzo King was arrested and charged with felony second-degree assault in a separate case. Relying on the state law that allowed warrantless DNA tests following some felony arrests, police took a cheek swab of King's DNA, which matched a sample from the 2003 rape. He was convicted of rape and sentenced to life in prison. Had that tool not been in the arsenal of police, a rapist would have been back out on the streets, and a victimized woman would never have had the justice or closure she deserved. There are many of you likely yelling at your television sets right now about your own personal freedom and about how government shouldn't be infringing upon your rights. And I do hear you. If this were the feds asking for a DNA sample from every Canadian, I would be the first to object. But it's not. Your DNA will in all likelihood never be collected. It is simply for those that find themselves arrested for serious crimes. I would hazard a guess that if you were in that position and innocent, you would welcome a DNA swab to clear your name. Yet the civil rights crowd will denounce this idea and use it to fuel the industry they have created based on fear. They will whip the public up into a frenzy and shout from the mountaintops about Big Brother taking over your life. Add to them the voices of defense lawyers across the country that, if this went through, would no longer be able to make a quick buck by helping violent criminals go free. Hopefully, sanity will drown out those voices, and the majority will realize fearing a murderer outweighs the idea of fearing a cotton swab.
This job really isn't how, shows like CSI make it out to be. When I first joined the force, I assumed there was semen on everything, and there was some, huge semen database that had every bad guy's semen in it. There isn't. That doesn't exist.
Well, he probably used that word one too many times, but this is going to be an ongoing debate in this country as to how comfortable you are with the federal government taking some swabs of criminals, or at least people who are arrested in this situation. Chris Schafer is the executive director of the Canadian Constitution Foundation and joins us to talk about this a little bit. First off, your general impressions as to where the federal government wants to head.
I think they obviously want to head a similar direction that the U.S. and other jurisdictions have. It provides a tool for them to, they would argue, do their job better, more efficiently. However, there are some concerns that I think are valid and ought to be pointed out.
All right, take me through those, because I talked about this on my radio show last night. I'm curious to hear what the fear is.
Well, there's several fears. First of all, a fingerprint is fundamentally different than a DNA swab. DNA swab contains much more information about an individual than a fingerprint does. So there's that concern there. The second concern then becomes what is done with that information in the database. If you are not convicted, or if the charges against you are dropped, does your DNA remain in the database, or is it destroyed? And if it does remain, or if you are convicted, and let's say you are a criminal, it's convicted, and it's just, what happens to that DNA sample in that database? Who has access to it? What safeguards are in place? And what prevents the government, as we know, they tend to start small and mission creep into other areas. What prevents a future government, maybe 10, 20, 50, 100 years from now, accessing that database and using the DNA samples for something altogether different than what was intended to be used in the first place?
Certainly we could find middle ground here. Shutting down the idea outright doesn't seem to be responsible to me.
No, I would argue, for example, I'm a lawyer, and if I was crafting legislation to make it sort of charter-proof, if you like, to prevent it from being struck down by the Supreme Court of Canada, there's no doubt ways you can draft legislation to do that. So, for example, you could have it only taken, DNA sample only taken upon conviction, maybe like the current situation, or if it is taken upon arrest, that it's destroyed if you're not convicted of a crime. If the allegations against you are dropped, then that DNA sample is destroyed. Proper safeguards are put in place in terms of accessing the database and what is done with the information, or perhaps all database samples, DNA samples are destroyed maybe after the death of a convicted person. You could probably structure a DNA database to allow for samples upon arrest if it was done in the proper way, and I would argue probably would pass muster at the Supreme Court if it was drafted a certain way.
Were you surprised, as I mentioned in the monologue, you know, the United States is all about freedom and all about civil liberties. Were you surprised that the Supreme Court ruled the way they did?
No, I'm not surprised. And I think often I'd correct your argument that the United States is a land of freedom, because they're often not. They were the first to introduce an income tax before we were. They are taking away land from people under a scheme that we've talked about on the show before. So they're often the first to violate your rights and freedoms despite the Bill of Rights in the U.S. So they're not necessarily always a land of freedom.
What about the argument that this does help the innocent? We've seen cases in Canada and the United States, probably more so down south, where we've had people jailed for decades, where the DNA evidence was out there, it just wasn't used, the technology wasn't put into effect, and it wasn't used to a point where the innocent were allowed to walk free when they didn't commit a crime.
Yes, no, I understand, because there's always the flip side of every argument, and that's a valid point. Nobody wants to see people that are innocent behind bars for a period of time. So perhaps there's a way you can draft in that legislation. Maybe there's voluntary processes that can be used to clear people. I'm not sure. But there's definitely got to be a middle ground. If you're going to go this route, what I want to see avoided is preferably DNA samples not taken upon arrest. That concerns me. But if they're going to go that way, and the law is going to get passed, and there have to be safeguards in place about who accesses the data, what is done with the data, and if it's destroyed, if you're not convicted ultimately of that crime.
What about the idea that this is just for certain crimes? Of course, you know, you could make the argument that you extend it, as you said, 50, 100 years down the road, government may take advantage of it. I don't necessarily buy into that, but let's talk about the crimes themselves. If we're talking about murders, sexual assaults, those type of things, crimes against kids, certainly those crimes are high profile. They're ones where we want to catch the right individual. If we keep it to that, would that be something you would be comfortable with the other safeguards you mentioned? Yeah,
the other safeguards, plus I think you're right, you would have to have the law designated to certain offenses. You couldn't have everyone, I would argue, that's been arrested have a DNA sample taken, because the law would probably be too broad then, and it would arguably would be a condition that the Supreme Court would probably say, oh, this law has gone too far, and they may err on the side of striking it down if it was challenged and ultimately drafted and brought into law and challenged at the Supreme Court. So I think that is a proper putting proper barriers or boundaries around a law. That is a good thing. However, I still have concerns about arrest versus conviction. Okay, where do you see this going? Because it would seem Peter MacKay is pretty hot on the idea. We already mentioned one of the police chiefs in Calgary. He likes the idea for his police force. Do you see this getting the green light? Perhaps, you know, a different kind of molded version, a Canadian compromise version where some of it is allowed? If I was a betting man, I would say we're heading there. I think the police have argued for a long time that their crime-fighting capabilities are hindered by the lack of available tools in this technological age we live in now. They're sort of fighting crime with 20th century tools, and criminals are using 21st century tools. So there has to be some, they argue, brought up to the same standards so they can fight crime adequately. So I think we're heading in that direction. I think the best thing, consensus and compromise that can be achieved is to take that law, because if we're going to get it anyways, how do we make it a better law to put in place some of those safeguards that civil liberties advocates like myself and the Canadian Constitution Foundation would want to see protect the privacy of Canadians.
And the beauty of it is we have a democracy where we can have the conversation. We appreciate the time.
Thanks for having me. Appreciate it.